The billing alert appeared at 11:47 p.m. on a Tuesday, flagging a $15,000 retainer payment that our case management system couldn't match to any active client. I stared at the notification on my laptop screen, the blue glow casting shadows across my Arlington office. Garrett Greenfield, 42 years old, senior partner specializing in federal contracting law at our mid-sized firm. 20 years of practice had taught me that unexplained money always meant trouble. The payment originated from Meridian Defense Solutions, a company I'd never heard of. According to our client database, they'd retained us 3 weeks ago for a procurement dispute. The problem was simple. I handled every federal contracting case personally, and I'd never met anyone from Meridian Defense Solutions. I pulled up our firm's social media accounts. Our LinkedIn page showed recent posts about successful contract negotiations, regulatory compliance updates, and client testimonials. Standard marketing content that our research assistant Benedict Inglewood managed. The posts looked professional, authoritative. Exactly what potential clients expected from a federal contracting practice. But something felt wrong. I scrolled through the comments section. Multiple inquiries from defense contractors asking about our services. Phone numbers I didn't recognize. Email addresses that weren't in our client management system. The engagement metrics showed unusual activity. Dozens of new followers. Shares from accounts I'd never seen before. My phone buzzed. A text from an unknown number. Thanks for the consultation today. Looking to working with your firm on the GSA contract issue. I hadn't conducted any consultations today. I'd spent the afternoon reviewing discovery documents for an existing client's bid protest case. The case management system showed 3 new client intake forms submitted in the past week. All defense contractors. All seeking representation for federal procurement matters. All claiming they'd spoken with someone from our firm who directed them to our website. I checked our phone logs. No record of incoming calls from any of these companies. No scheduled appointments. No consultation notes in our files. The retainer payments kept appearing in our trust account. $15,000 from Meridian Defense Solutions. $22,000 from Apex Government Services. $18,000 from Strategic Federal Partners. Companies that existed according to their corporate filings, but had somehow engaged our services without my knowledge. Our website analytics showed a 300% increase in traffic over the past month. The referral sources pointed to social media platforms and legal directories where our firm apparently maintained active profiles. Profiles I'd never created or authorized. I opened our firm's Facebook page. Professional photos of our office building. Detailed descriptions of our federal contracting expertise. Client testimonials praising our successful bid protest representations and regulatory compliance work. The page had been active for months, posting regular updates about changes in federal acquisition regulations and procurement law developments. The problem was that I'd specifically decided against social media marketing 2 years ago. Too much liability exposure. Too many potential ethical violations. Our partnership agreement explicitly prohibited any marketing activities without unanimous partner approval. Yet here was of an extensive online presence that had been generating client leads and retainer payments without my involvement or consent. I checked the administrative access logs for our website and social media accounts. The activity timestamps showed regular updates and client communications occurring during hours when our office was closed. Late evening posts. Weekend client responses. Early morning consultation scheduling. Benedict had been working late frequently, staying after hours to help with case research and document preparation. Dedicated employee. Recent law school graduate with strong technical skills and social media expertise. He'd volunteered to help modernize our marketing approach several times, suggestions I'd consistently declined. The trust account balance showed $127,000 in unaccounted retainer payments from companies I'd never agreed to represent. Money that legally belonged to clients I'd apparently never met, for services I'd never contracted to provide. My hands trembled slightly as I reached for my phone to call our bank's fraud hotline. The bank confirmed my worst fears within 20 minutes. 17 unauthorized deposits over the past 4 months. All electronic transfers from companies seeking federal contracting legal services. Each deposit accompanied by signed retainer agreements bearing my electronic signature and our firm's letterhead. I'd never seen these agreements before. Never spoken to these clients, never authorized these signatures. Benedict Inglewood had joined our practice 8 months ago, fresh from Georgetown Law with impressive credentials in government contracts and procurement law. His resume showed internships at major federal contracting firms and a law review article on bid protest procedures. During his interview, he demonstrated remarkable knowledge of our client base and federal acquisition regulations. I'd hired him immediately. Solo practitioners in Arlington's competitive federal contracting market needed talented associates who understood the complex regulatory landscape. Benedict seemed perfect for our growing practice. He'd quickly proven invaluable. Late nights researching procurement regulations, weekends preparing bid protest filings, early mornings reviewing contract modifications and compliance requirements. His dedication impressed our existing clients and helped secure several major retainer agreements. The partnership had been considering promoting him to junior associate status. His billable hours exceeded expectations. Client feedback was consistently positive. He'd even suggested expanding our marketing presence to attract more federal contracting work. I declined his marketing proposals, preferring our established referral network and reputation-based client development. Social media marketing felt too risky for a practice handling sensitive government contract disputes and regulatory compliance matters. Now I understood why he'd been so persistent about modernizing our outreach efforts. I pulled Benedict's employment file and reviewed his access permissions. Full case management system privileges. Client database access. Document preparation authorization. Electronic signature capabilities for routine correspondence and filing deadlines. Standard permissions for a trusted research assistant handling complex federal contracting matters. The case management logs showed his activity patterns over the past 4 months. Regular after-hours access to client files. Weekend database queries for company information and contact details. Late-night document creation and email communications with unauthorized clients. He'd been systematically using our firm's reputation and my professional credentials to solicit new business. Creating social media profiles. Responding to legal directory inquiries. Scheduling consultations with companies seeking federal contracting representation. The electronic signature software showed 43 documents bearing my authorization that I'd never reviewed or approved. Retainer agreements. Engagement letters. Fee arrangements. All professionally drafted using our standard contract templates and legal language. Benedict had access to our template library. He'd helped update several standard agreements over the past few months, improving language clarity and adding provisions for complex procurement disputes. I'd trusted his legal research skills and attention to detail, never questioned his document revisions or template modifications. The phone records from our office system revealed the scope of his deception. Hundreds of calls to potential clients during lunch breaks and after-hours periods. Professional conversations about federal acquisition regulations, bid protest procedures, and regulatory compliance services. He'd been running a parallel practice using our firm's infrastructure and my professional reputation. The trust account statements showed a sophisticated money management scheme. Client retainer payments deposited into our legitimate business account. Funds then transferred to a secondary account I'd never authorized. Monthly transfers back to our operating account to cover his salary and office expenses. He'd been essentially paying himself from stolen client funds while maintaining the appearance of normal business operations. I called our malpractice insurance carrier to report the potential fraud. The claims representative explained that unauthorized practice activities could void our coverage for any resulting lawsuits or disciplinary actions. Professional liability policies required full disclosure of all practice activities and client relationships. Benedict had exposed our firm to massive liability without my knowledge or consent. The social media profiles showed client testimonials praising legal services I'd never provided. Successful bid protest representations for companies I'd never heard of. Regulatory compliance victories in matters I'd never handled. He'd been fabricating our track record to attract additional business. I reviewed the actual case files for our legitimate clients. Several recent matters showed unusual billing discrepancies, hours attributed to my work that I'd never performed. Legal research and document preparation, billed at partner rates for services Benedict had provided. He'd been inflating our legitimate billings while simultaneously operating his unauthorized practice. The Virginia State Bar's ethics hotline confirmed my obligations. Immediate disclosure of the unauthorized practice. Full accounting of client funds. Cooperation with any disciplinary investigation. Potential suspension of practice privileges pending resolution. My 20-year legal career was at risk because of Benedict's betrayal. I printed copies of all relevant documents. Bank statements. Case management logs. Social media profiles. Client communications. Electronic signature records. Phone logs. The filled 3 banker's boxes. Benedict was scheduled to return from lunch in 15 minutes. I had to decide whether to confront him immediately or involve law enforcement first. The unauthorized client retainer payments totaled $127,000. Federal wire fraud, identity theft, professional impersonation, criminal charges that could result in significant prison time. But I also needed to protect our legitimate clients and preserve what remained of our firm's reputation. I called the Legal Standards Enforcement Bureau to report the suspected fraud. They introduced me to their Bar Association allies and scheduled an emergency investigation meeting for the following morning. Benedict walked through our office door at exactly 1:30 p.m., carrying coffee and wearing the confident smile that had convinced me to trust him with our firm's future. "Benedict, we need to talk," I gestured toward the conference room. "Close the door behind you." His smile faltered as he noticed the banker's boxes on the table. The printed. The Virginia State Bar Ethics Guidelines spread across the mahogany surface. "What's all this about?" He set down his coffee with deliberate care. I slid the bank statements across the table. Unauthorized client retainer payments. $127,000 in fraudulent billings. Social media impersonation of our firm. Benedict's face went pale. He picked up the top document with trembling fingers. "I can explain this. You've been operating an unauthorized practice using our firm's identity. Fabricating case victories. Billing clients for services I never provided. This constitutes federal wire fraud." "Garrett, listen to me." Benedict sat down heavily. The firm was struggling. You were so focused on the major cases that you didn't see the financial pressure we were under. So you decided to commit multiple felonies? I was trying to save our practice. Those clients received quality legal services. I handled their matters competently. I opened the case management system on my laptop. "Show me your bar admission number. Your malpractice insurance. Your client trust account authorizations." Benedict stared at the screen without responding. "You're not licensed to practice law in Virginia. You've been impersonating an attorney for 8 months. The clients were satisfied with the outcomes. That's not the point. You've exposed our firm to massive liability, criminal prosecution, bar discipline, civil lawsuits from every client you defrauded." My phone buzzed with a text from revenue tracking specialist Jason Ali. "Emergency meeting confirmed for tomorrow 9 a.m. Bring all documentation." Benedict noticed the message. "You've already reported this?" I had no choice. The Virginia State Bar requires immediate disclosure of unauthorized practice. The Legal Standards Enforcement Bureau is investigating federal wire fraud charges. "Garrett, please, we can work this out internally. I'll return the money. Dissolve the fake social media accounts. No one has to know." 17 clients know. The banking records are permanent. Your electronic signatures are documented of identity theft. Benedict stood up abruptly. "I need time to think about this. You need to contact a criminal defense attorney. Today." "Are you firing me?" "I'm terminating your employment immediately. You're banned from accessing our case management system, client files, and office premises. Security will escort you out." Benedict gathered his personal items while I watched. His hands shook as he packed his law school diploma and family photos. The confident research assistant who'd impressed me during his interview had vanished. "I trusted you with our firm's reputation," I said. "Our clients' confidential information. Our financial future. I know I made mistakes. You committed federal crimes. There's a difference." After Benedict left, I called our malpractice insurance carrier. The claims representative scheduled an emergency review for the following week. Potential coverage exclusions for criminal acts. Possible policy cancellation. Premium increases that could force us to close. I then contacted each of Benedict's unauthorized clients. 17 difficult conversations explaining the situation. Offering to transfer their files to qualified attorneys. Providing documentation for potential malpractice claims. 3 clients immediately threatened lawsuits. 2 demanded full refunds plus damages. 1 client had relied on Benedict's fabricated regulatory compliance advice for a major federal contract bid. The Virginia State Bar's Disciplinary Counsel returned my call at 4:30 p.m. "Mr. Greenfield, we're opening a formal investigation into your firm's supervision practices. You'll need to appear before the disciplinary board next month." I reported the unauthorized practice immediately upon discovery. "That's noted in your favor. However, the board will examine whether adequate supervision protocols were in place." My 20-year legal career faced potential suspension because I'd failed to detect Benedict's deception sooner. The next morning, I met with Jason Ali at the Legal Standards Enforcement Bureau's Arlington office. He reviewed my methodically. Bank records, social media screenshots, client communications, billing discrepancies. "This appears to be a clear case of wire fraud and identity theft," Ali said. "We'll coordinate with the Virginia State Bar's investigation." "What's the timeline for criminal charges?" "Federal prosecutors will review the case within 30 days. The unauthorized practice alone carries significant penalties. The financial fraud adds federal jurisdiction." Ali explained the investigation process. Subpoenas for Benedict's personal financial records. Interviews with defrauded clients. Analysis of electronic communications. Coordination with State Bar disciplinary proceedings. "Will our firm face criminal liability?" "That depends on regarding your knowledge and involvement. Your immediate reporting suggests good faith cooperation." I returned to the office to find Ophelia Inglewood, our office manager, fielding angry calls from Benedict's clients. She'd worked with our firm for 12 years and understood the gravity of our situation. 3 more clients called demanding explanations, she reported. The regulatory compliance client is threatening a federal lawsuit. Schedule meetings with all affected clients. We need to document the full scope of Benedict's unauthorized practice. What about our legitimate cases? The partners are asking questions. Our firm's 3 senior partners had built their reputations over decades. They deserved honest explanations about the crisis threatening our practice. I called an emergency partnership meeting for that afternoon. The conference room felt smaller with all 4 partners present. I distributed copies of the and explained Benedict's betrayal systematically. "How did this happen without our knowledge?" asked the managing partner. "Benedict had administrative access to our case management system. He created separate client files that didn't appear in our standard reports." "What's our potential liability exposure?" "Malpractice claims from 17 clients. Federal criminal investigation. State bar discipline. Possible insurance policy cancellation." The partners discussed damage control strategies, client retention efforts, public relations management, financial reserves for legal defense costs. "We need to consider dissolution if the liability exposure becomes unmanageable," one partner suggested. "I'm committed to preserving our firm's reputation," I replied. "We'll cooperate fully with all investigations and make our clients whole." 2 weeks later, federal prosecutors filed criminal charges against Benedict. Wire fraud, identity theft, unauthorized practice of law, potential prison sentence of 15 years. The Virginia State Bar suspended Benedict's law school transcript privileges and banned him from future bar admission attempts. They also issued a public censure of our firm for inadequate supervision but allowed us to continue practicing under enhanced monitoring protocols. Our malpractice insurance carrier agreed to cover legitimate client claims, but excluded coverage for Benedict's unauthorized practice. We established a victim compensation fund, using firm reserves to address the excluded claims. I spent the following months rebuilding client relationships and implementing new supervision protocols. Electronic access controls, daily billing reviews, client verification procedures, background checks for all staff members. The federal contracting practice slowly recovered as word spread about our cooperation with investigators and commitment to client protection. Several clients praised our handling of the crisis and referred new business. Benedict pleaded guilty to federal wire fraud charges and received a 3-year prison sentence. He was ordered to pay $127,000 in restitution to defrauded clients and banned from working in any legal capacity. The Legal Standards Enforcement Bureau closed their investigation after confirming our cooperation and implementation of enhanced compliance measures. Jason Alley commended our firm's response to the crisis. But the betrayal had fundamentally changed my perspective on trust and supervision in legal practice. 6 months after Benedict's sentencing, I opened my own practice in downtown Arlington. Greenfield Legal Services. Federal contracting law. Solo practitioner with carefully vetted contract attorneys for overflow work. The new office occupied a modest suite on Wilson Boulevard. Clean lines, minimal furniture, no research assistants. I handled all client intake personally and maintained direct control over every case file. My former partners had dissolved the original firm after 2 more clients filed malpractice suits. The insurance settlements and legal fees had depleted their reserves. They scattered to different practices across the region. I kept in touch with Ophelia Inglewood, who had joined a boutique employment law firm in Tyson's Corner. She occasionally referred federal contractor clients who needed specialized representation. Our professional relationship had strengthened through the crisis. "You seem more focused now," she observed during a recent lunch meeting. "Less trusting, but more effective." She was right. I had implemented strict protocols for client verification and case management. Every document required my personal review. All financial transactions needed dual authorization. Technology access remained limited to essential functions only. The practice grew steadily through referrals from satisfied clients and former colleagues who respected my handling of the Benedict situation. Word had spread through Arlington's legal community about my cooperation with investigators and commitment to client protection. I published essays on power abuse in elite firms for the Virginia Bar Association Journal. The articles examined supervision failures and recommended enhanced oversight protocols for law firms. Several state bar associations requested permission to reprint the pieces. The federal contracting practice had evolved into something more sustainable: smaller client base, higher quality work, direct attorney-client relationships without intermediaries. I knew every case personally and maintained complete control over all aspects of representation. Benedict had been released to a halfway house after serving 18 months of his sentence. The restitution payments continued through a court-supervised payment plan. I occasionally received updates from the victim compensation administrator. Some evenings I walked past our old office building on my way to the metro station. The space now housed a consulting firm specializing in government relations. No trace remained of our former practice or the betrayal that had destroyed it. The experience had taught me valuable lessons about trust and verification and professional relationships. I had learned to distinguish between healthy skepticism and paranoid micromanagement. The balance required constant attention but had become second nature. My new practice operated with transparency and accountability as core principles. Clients received detailed billing statements and regular case updates. Staff members underwent comprehensive background checks and signed enhanced confidentiality agreements. The betrayal had cost me a partnership and several years of career momentum. But it had also forced me to examine my assumptions about supervision and trust in legal practice. The resulting changes had made me a more effective attorney and a more careful business owner. I still represented federal contractors navigating complex regulatory requirements. The work remained challenging and intellectually stimulating. But now I approached each case with hard-earned wisdom about the importance of verification and oversight. The sun was setting over the Potomac as I locked my office door and headed home. Another successful day of practice. Another step in rebuilding my professional reputation. Another reminder that trust, once broken, could be rebuilt through consistent action and transparent communication. It was finally over, and the silence felt earned.